Reborn, I filed the patent before I signed his partnership agreement. He never got to steal what was already mine. Wesley had 7 years to plan what he did to me, 7 years of watching me develop the research, draft the technical documentation, build the methodology that became the foundation of everything our company was worth. He waited until the week before our public launch to file it under his name alone. Then, he used a fabricated report about my mental stability to have me removed from the board before I could contest it. In my first life, I spent 4 years trying to prove what he took. In my second life, I woke up on the morning of the partnership signing with every clause of every document already mapped. I filed the patent at 8 in the morning. I walked into his office at 9 with a confirmation number in my pocket. He slid the agreement across the table. I smiled and read every word before I picked up the pen. I want to tell you what it felt like to wake up in the second life, knowing exactly what the morning was. The first thing I noticed was the quality of the light, that specific October morning light coming through the window of my apartment. A light I had woken up in hundreds of times over the 7 years of building the company and had never particularly noticed until I was lying in a hospital bed in my first life watching a version of it through a different window, thinking about all the mornings I had not used correctly. I was 34 years old. The partnership signing was at 9. The patent filing portal opened at 8. My name was Margot. I had 1 hour. I did not panic. I had carried the knowledge of what was coming for the entirety of my second life. I had been reborn with it intact, a complete accounting of the 7 years I was about to relive, and I had used those years to build what the first life had not had, a trail of documentation so thorough and so precisely attributed that there was nothing left for anyone to claim. The morning of the signing was not the beginning of the reversal. It was the final piece of it. The patent application had been in progress for 3 months. This morning was the morning I submitted it. I got up. I made coffee. I opened my laptop and completed the filing. The confirmation arrived at 8:17. I printed it, folded it, and put it in the inside pocket of my jacket. Then I went to meet Wesley. Let me tell you about Wesley first, because the story is not simply about what he took, but about how long he had been positioning himself to take it, and the patience required for that kind of positioning is worth examining clearly. We had met at a biotech conference 7 years before the signing, when I was 27, and in the final stages of the foundational research that would become the basis of our company. He was 30, working in business development for a mid-sized pharmaceutical firm, and he was, I want to be accurate about this, genuinely impressive in the room. He had the specific quality of a person who understands how power moves in professional spaces, who to talk to, how to listen, when to speak, how to make the person across from him feel that they have been seen and understood, and that whatever they are working on has enormous potential. He made me feel all of those things at that conference. I believed him. I had built my professional identity around the quality of my scientific work, which was excellent, and which I knew was excellent, but I had no natural facility for the other side of building a company, the fundraising, the investor relations, the specific theater of convincing people with money that the thing you have built is worth believing in. Wesley had that facility entirely. We looked, to both of us, like a perfect complement. We founded Helix Biotech 9 months after the conference. The initial split was equal, 50-50 equity, equal titles, equal board seats. On paper, a partnership. In practice, a division of labor that felt so natural in the early years that I did not examine its long-term implications with anything like the rigor I would have applied to the science. I did the science. That was the clean version. The more accurate version was, I developed the molecular targeting platform that became the company's core intellectual property. I wrote the technical documentation that made it legible to the patent examiner and to the board and to every investor who needed to understand what they were funding. I supervised the lab research that validated the methodology across 2 years of testing. I authored the scientific papers that established the platform's credibility in the peer-reviewed literature. And I mentored the research team, including Min, our lead research scientist, who had come to us from a university lab and who was the only person in the company whose understanding of the underlying science was as complete as mine. Wesley raised the money. He pitched the vision. He managed the board relationships. He cultivated the investors who came in at Series A and positioned us for Series B. He was genuinely good at all of it. The fundraising rounds were successful because he understood how to present the work I was doing in a language that translated its value into something that people who did not understand molecular biology could nonetheless feel excited about funding. That translation was a real skill, and he performed it well. I want to be precise about this because accuracy requires it. In the early years, the arrangement worked. The first 2 years of Helix Biotech were the most energized period of my professional life. The lab was producing results. The MAST platform was developing faster than I had projected. Min had joined and immediately become the research collaborator I had not known I needed, precise, tireless, with an instinct for the gaps in my methodology that improved the work at every stage. Wesley was closing the Series A with a confidence and ease that I found genuinely impressive. Every board meeting in those first 2 years felt like we were all looking at the same thing from different angles, and the angles were complementary. The shift happened gradually enough that I had no clear date for it. I can identify the texture of it now, the specific quality of a working relationship that has begun to organize itself around one person's advantage rather than both people's contributions, but at the time it felt like the natural evolution of a company moving from startup to growth stage. Roles clarified. Responsibilities consolidated. The people who were good at specific things were given more of those specific things to do. I was given more science to do. Wesley was given more board access. These were natural allocations. I chose to see them that way because the alternative, examining what the allocations were producing in terms of how the company's narrative was being constructed, would have required a kind of vigilance I had not been applying to my professional life that was not my research. In my 4th year, we had a series of close dinner with the major investors and the board. Wesley spoke for 40 minutes about the company's vision and trajectory. I spoke for 8 minutes about the scientific platform. When I finished, the board chair said, "Dr. Margot, Wesley always says you're the engine under the hood." I think that's the most apt description I've heard. He said it warmly and generously, and as a compliment. I smiled and thanked him. Engine under the hood. Not the car. Not the driver. The engine, the thing that makes it move, without which nothing works, and which is most legible to the people outside the vehicle in terms of what the car can do rather than in terms of what the engine is. Min caught my eye across the table. I looked away from her, because looking at her would have required acknowledging what I had just been told, and I was not ready to fully acknowledge it in that room. The problem was not that he did the front-facing work. The problem was what he was doing with the front-facing work while I was not paying sufficient attention to the back end. He was building relationships with the board members that did not include me. Not overtly, there were no meetings I was explicitly excluded from, no communication I was obviously not copied on. But there was a texture to his board relationships that was different from mine in a way I could feel, but had not examined carefully enough. They called him Wesley. They called me Dr. Margot, which is a form of address that is respectful and also, in a boardroom context, a form of address that positions its recipient as a technical resource rather than a business leader. He had dinners with them. I had presentations. He attended the golf events and the charity galas where the informal relationships that govern formal decisions are built and maintained. I was usually in the lab on those evenings or writing or reviewing data, because those were the evenings when the lab was quiet and I could think clearly. He managed the board summaries. This was the specific mechanism I had not understood in my first life until I had spent 4 years of it trying to reconstruct what had happened. The board received a monthly summary of the company's progress, prepared by Wesley's office, which covered financials, milestones, strategic developments, and, crucially, a narrative account of how the company's value was being created and by whom. Those summaries were accurate in their facts. They were Wesley's version in their framing. Over 6 years, 37 times a month, board summary after board summary. The story the board received about Helix Biotech was a story in which Wesley identified opportunities and directed the company's strategy, and the technical team, led by Dr. Margot, executed the scientific work that supported that strategy. I was the execution. He was the strategy. The story was told so consistently and for so long that by the time of the patent dispute, it was not a story anymore. It was the board's understanding of reality. By the time I was in our 6th year, The board understood the company's value proposition in Wesley's terms, which were commercial and strategic, and regarded the scientific foundation of that value proposition as an asset that Wesley had identified and was managing. I was the asset. I had not seen this framing clearly while it was being built, which was the specific failure of my first life that I understand best now. I had been so focused on the work that I had not been tracking how the work was being framed to the people who controlled the company's direction. Min saw it. Min had been in the lab since the second year, and she had a precise view of what the work was and who was doing it, and she had said to me in the third year, over coffee after a board meeting where Wesley had described the MAST platform as his team's breakthrough, "Margot, do they know you built this?" I had said yes. I had believed yes. I had been wrong. The formal documentation trail was the specific mechanism he used. Every piece of research I produced was correct and detailed in the lab notebooks and in the technical filings. But the narrative framing of that documentation, the cover reports, the board summaries, the investor updates, was managed by Wesley's office, which meant that the story the board received about where the intellectual property came from was Wesley's version of it. Not fraudulent, not overtly. He did not claim the science as his own in those documents. He simply described it in language that attributed the vision to himself and the execution to the team, and gradually, over 6 years of consistent framing, the board's understanding of the company became: Wesley had the vision, the team implemented it, and the most senior member of the implementation team was the person they called Dr. Margot. The platform was called MAST, Molecular Affinity Sequencing Technology. I had developed it over 4 years before we founded the company and the 2 years following, and it was the thing that made Helix Biotech worth the money we were raising and the attention we were receiving. Without MAST, there was no company. There was Wesley with a pitch deck and no science behind it. Without Wesley, there was me with the science and no one to put it in front of the right people. That was what had felt like partnership. That was what had made the next 7 years feel collaborative rather than extractive. That was why, when the extraction happened, I had not seen it coming from the direction it came. The launch was scheduled for the 23rd of October, a public announcement and Series B close that would value the company at a figure that made every conversation about equity and IP protection suddenly and acutely significant. The patent for MAST had been in the plan for 2 years. I had been meaning to file it and had deferred, repeatedly, to Wesley's timeline on the grounds that the filing needed to coordinate with the funding round, with the board approvals, with the legal review. There was always a reason the timing was not quite right, and I had accepted each reason at face value because the reasons were never wrong. Exactly, they were just reasons. On the 15th of October, Wesley filed the MAST patent under his own name as sole inventor. I found out from Min, who had been reviewing a related filing for a component of the platform and had noticed, in the database, that a patent application for MAST had been submitted 2 days prior.
She called me.
She read me the inventor name from the application. There was a silence on the phone that had a specific quality, the quality of a silence between two people who have both understood something at exactly the same moment. I called Wesley. He said there had been a filing decision that needed to be made quickly given the launch timeline, and that the IP structure worked better for the board with a single listed inventor, and that we could discuss the attribution arrangements separately, and that he was surprised I was reacting this way given how much work he had put into getting the company to this point. I went to the board. The board meeting was a week before the launch. I presented the documentation, the research notebooks, the technical papers, the lab records, the timeline of development that demonstrated clearly and specifically that MAST had been my work. I was precise and thorough, and I did not raise my voice, and I made the case as professionally as I had ever made any professional case. The following day, Wesley presented the board with a report prepared by a physician named Dr. Brennan, a man I had never met, who had never treated me, whose assessment of my mental state had apparently been formed on the basis of conversations with Wesley about my recent behavior and demeanor. The report described concerns about my judgment, my emotional stability, my capacity to manage the stress of the company's growth phase. It said, in careful clinical language, that my reaction to the patent filing indicated a level of distress inconsistent with effective executive function. The board voted to place me on indefinite administrative leave, pending review. I was escorted from the building by security. I spent 4 years after that in the specific occupation of a person who knows she has been wronged and is trying to prove it through channels designed for a different kind of wrongness. The legal proceedings were expensive and slow and ultimately unsuccessful. The patent had been filed, the board had voted, and the documentary trail that Wesley had built over 7 years of board summaries and investor updates framed the IP as his vision in a way that my lab notebooks, however accurate, could not overcome without a level of legal resources and institutional credibility I was spending down trying to fund the fight. The first year was the most energized because I still believed the truth was legible enough to be recognized once someone was looking at it properly. I had a lawyer. I had the documentation. I had Min's testimony. I had the dated notebooks and the peer-reviewed papers and the research timeline that was, to anyone who examined it carefully, a clear record of where Mast had come from and who had built it. The problem was that the legal process was not examining it carefully. It was examining the patent filing, the board vote, the partnership agreement as it had been signed, without the IP clause that Clara had added in my second life, and Wesley's 7 years of board summaries, which had established his framing as the one the company's governance history recognized. My evidence was accurate. His narrative was the one the record showed. By the second year, I had spent most of my savings. I had taken a research position at a university laboratory, useful work, real work, but below what I had been doing and without the resources that Helix had provided. I worked during the day and worked on the legal case in the evenings, and by the third year, I was doing neither as well as I needed to because I was too depleted to do both properly. Min visited when she could. She had remained at Helix. She had the lab to run and the research to protect, and she was doing both while quietly preserving the documentation of what she knew. She told me, in the third year, that the Mast platform was being commercially developed without the foundational refinements she and I had made in the final 18 months before the theft, because Wesley's team didn't fully understand what the refinements were for. She said the outcomes would be worse for it. I asked her to document everything. She said she already was. In the fourth year, the legal motion failed on procedural grounds for the second time, and I did not appeal it because I had reached the limit of what I could fund and continue to function. I closed the case. I went back to the university position. I began very slowly to think about what rebuilding meant when the thing you had built was still in existence and someone else's name was on it. I was thinking about this at my desk on a Tuesday evening, reviewing a different document for a completely different purpose, when the stroke came. I was 38 years old. The motion I had decided not to appeal was still open in a browser tab behind the document I was reading. I remember noticing, in the moment before the stroke arrived, that the window behind the document showed Min's name in one of the footnotes of the legal brief, and thinking that I should have protected her contribution more formally from the beginning. I was still thinking about that when I woke up at 34, on the morning of the signing, with the patent confirmation processing and the revised partnership agreement in Clara's hands and Min's collaboration records 2 years into their documentation. I had not waited for this morning to act. That was the most important structural difference between my first life and my second. In the first life, I had deferred to Wesley's timelines, to the board's processes, to the general forward momentum of a company that always seemed to have a reason why this was not quite the right moment for me to establish what was mine. In the second life, I had understood, from the first morning of it, that the right moment was always now, and that the only person who would create the right moment was me. The patent application had been filed in draft in the first month of the second life. I had worked with a patent attorney, a woman named Clara who specialized in biotech IP and whose analysis of the Mast documentation was unambiguous about what it established and who had created it, to prepare a filing that was complete, precise, and built on the most comprehensive documentation of the research timeline that had ever existed. I had pulled every notebook, every dated file, every time-stamped communication from the development period and organized them into an IP record that could not be revised by narrative framing or board summary. The filing itself named me as sole inventor. The documentation behind it was 3,700 pages. Let me tell you what Mast actually was, because the science is part of the story and deserves to be described accurately. Mast, molecular affinity sequencing technology, was a platform for identifying cancer cells through specific protein markers and delivering therapeutic agents with precision that reduced collateral damage to healthy tissue. The foundational challenge in cancer treatment has always been specificity. How do you target what you want to target without affecting what you don't? The existing approaches in the field when I began the work either lacked the resolution to distinguish between cell types at the required level of precision, or required a delivery mechanism too blunt to use the distinction effectively even when it was available. MAST addressed both problems simultaneously. It used a sequencing approach I had developed for my doctoral research to identify the specific protein configurations on cancer cell surfaces with a resolution that was, at the time of filing, an order of magnitude better than the existing state-of-the-art. It then paired that identification with an affinity-based delivery mechanism that I had spent 18 months developing and validating with MIN, a mechanism that used the identification data to route therapeutic agents directly to the flag cells through a biological targeting process that left the surrounding tissue essentially unaffected. It was, to put it simply and accurately, the most significant scientific work of my career. It was also, and this was the detail that the board summaries had systematically obscured, work that had taken me 7 years and could not have been reproduced by anyone who had not done it. Wesley could describe MAST in a pitch meeting. He could not have developed it, could not have validated it, could not have written the technical documentation that made it patentable. The platform existed because I had built it. 3,700 pages of documentation said so, in enough detail that the claim was irrefutable to anyone who actually read them. Min had been involved from the beginning of the Second Life. I had told her in my second month back that I was filing the patent and that I needed her collaboration documented properly, formal research collaboration agreements, her name on all records of the work she had contributed to, dated and witness sign-offs at every significant stage of development. She had looked at me across the table in the lab and said, "You should have done this from the start." I said, "I know." She said, "What changed?" I said, "My understanding of the timeline." She had looked at me for a moment with the specific quality of attention she applied to problems that were not quite yielding their full information, and then she had nodded and helped me build the documentation without pressing for the explanation I could not give. The partnership agreement I walked into that morning was not the one I had signed in my first life. Clara had reviewed it 2 weeks before the signing date and identified 8 points requiring amendment. The most important was the IP attribution clause, a provision specifying that all research and technical work developed by either partner prior to the agreement date remained the individual intellectual property of the developing partner, and that any jointly developed subsequent work would be documented with clear dual attribution within 30 days of development. This clause, attached to the MAST patent already on file, created a legal structure around my work that could not later be reframed by board narrative or investor summary. I had sent Wesley the revised agreement 10 days before the signing. He had called me the same evening. He said the IP clause was unusual and complicated the company's ownership structure, and that investors preferred consolidated IP, and that this was not how he had envisioned the partnership working. Each of these statements was true in its own way. Each of them was also an explanation of why the clause was exactly necessary. I said, "The clause stays. Clara can speak with your lawyer about implementation if you have specific structural concerns, but the attribution provision is not negotiable." A silence. "Of course. Let's talk in the morning." We talked in the morning. He arrived at 9 with the original agreement, not the revised version, under his arm, and the specific energy of a man who has decided to handle a problem by not acknowledging it. I was already seated at the table with the revised version, Clara's analysis, and the patent confirmation that had arrived at 8:17. He set the original agreement on the table between us. He did not push it toward me. He said he had been thinking, and he wanted to discuss whether the IP clause was actually serving the partnership's interests and whether there was a version that addressed my concerns while maintaining a cleaner legal structure. I picked up the revised agreement from my side of the table. I set it beside his. I said, "This is the version I'll be signing. If there's a specific clause you want to discuss, I'm available for that conversation. If the discussion is about whether the IP clause exists, that conversation is finished." He looked at the 2 documents on the table. He looked at me. Something crossed his face that I had not seen from him before, a specific quality of recalibration, the expression of a man who has walked into a room expecting a certain kind of meeting and has realized a few sentences in that he is in a different room entirely. He picked up the revised agreement. He read it. He signed it. I signed it after him. The confirmation number was in my pocket. The documentation was in the server. Min's records were 2 years into their archive. Clara's clause was in the document he had just signed. The agreement was done. Wesley made his move on the 15th of October, exactly as he had in my first life. He filed the patent for Mast under his name as sole inventor. The patent office rejected the application within 48 hours. Prior art, filed 2 years for months and 17 days earlier. Under my name. He went to the board anyway, with the reframed narrative, the 6 years of board summaries that positioned the IP as his vision, the network of relationships he had built that made his version of events the one the board was most prepared to receive. He presented the case that my prior filing had been a unilateral action that violated the spirit of the partnership, that I had acted without consultation, that my behavior indicated a pattern that the company could not afford at this stage. The board chair listened to the presentation. He was a careful man who had been on 3 biotech boards before ours and who understood, at a level Wesley may have underestimated, what a patent filing and an IP attribution record actually constituted. He asked Wesley several questions about the development timeline of Mast. Wesley answered them in the language he had always used: vision, strategy, team execution, my direction of the research effort. The board chair wrote something on the notepad in front of him and did not show it to anyone. Then the board received Clara's analysis of the IP clause in the partnership agreement Wesley had signed, the patent filing timeline, and Min's formal letter documenting her role as research collaborator and her direct account of the development of Mast from the initial methodology through the validation testing through the final platform specifications. Min's letter was 11 pages. She had been preparing it for 2 years. It contained dates, data, her own lab notebook entries, and a section at the end that described, in precise and specific language, the difference between what had been built and by whom, and what the board summaries had said about that. Then the board received the Brennan report. I had been expecting it. I had my own physician's report beside me on the table, prepared the previous month by my doctor of 11 years, who had examined me and found nothing inconsistent with effective executive function, and who had written her assessment in the same clinical register as Brennan's, allowing the board to place both documents side by side and assess them comparatively. I had Clara's letter. I had Min's letter. I had a sealed envelope that I handed to the board chair at the start of the meeting, before Wesley had spoken, which contained a legal brief documenting the specific mechanism by which a fabricated medical report used to remove a director from a position of authority constituted actionable fraud, the precedents for such cases in corporate law, and a notice that the brief had been filed with the appropriate regulatory authority that morning. Wesley looked at the envelope when I handed it over. He looked at me. I met his eyes and said nothing and picked at my coffee cup. The board meeting lasted 3 hours and 20 minutes. I did not raise my voice once. I presented the IP documentation in the precise, structured language of someone who has spent 2.5 years building a record for exactly this audience, and I answered every question directly and completely, and when Wesley made a statement that was inaccurate, I corrected it with a document that demonstrated the inaccuracy, and I let the documents do the rest. At the end of the 3rd hour, the board chair asked Wesley to step out of the room. Wesley looked at me again when he stood to leave. It was a different look from the one he had given me at the signing. Something had shifted in the quality of his attention, as though he was, for the first time in 7 years, actually looking at me rather than at his version of what I was. Whatever he saw, he said nothing about. He left. The door closed behind him. The board chair looked at the table for a moment. He was a careful man who had been on 3 biotech boards before ours and who understood, at a level Wesley had perhaps not fully accounted for, what 3,700 pages of IP documentation and a rejected patent filing actually meant about a contested ownership claim. He looked at his notepad. He looked at Min's letter, which he had been reading during the session with the specific attention of someone who had been given information he wished he had received earlier. He said, "Dr. Margot, I owe you an apology for the engine under the hood comment." I said, "It's noted." He said he would like to see the full documentation package filed with the company's records by the end of the week. I said Clara would have it there by Wednesday. He said he appreciated the thoroughness of the preparation. I said thoroughness had always been a characteristic of my work and I intended to continue applying it. He smiled slightly. He said, "I can see that now." The meeting ended. The board upheld the prior filing. Wesley resigned 6 weeks later, citing a desire to pursue independent ventures, in the formal language of a resignation that both parties understood was the agreed minimum necessary to avoid what the sealed envelope had already established was possible. The resignation was accepted with appropriate professionalism. He came to arrange the company around himself. He had not been watching carefully enough to see that I had been arranging it around the truth the entire time. I kept the company for 9 years after Wesley's departure. The MAST platform was licensed to 3 pharmaceutical firms beginning in the 4th year. The licensing structure Clara had negotiated was one that retained the foundational IP with Helix and licensed the application rights on a territory-specific basis, which meant that the revenue came in as recurring payments rather than a single acquisition, and that the scientific development continued under Min's direction rather than being absorbed into a larger organization's priorities. The company went public in the 7th year. The IPO prospectus described the founding story accurately. My name was on the patent. The research timeline was in the filing. Min's contribution was acknowledged in the technical documentation in the way that Min's contribution had always deserved to be acknowledged, which is to say specifically and prominently rather than as a general reference to the team. The board chair remained on the board for the full 9 years. He was the only original board member who had done so. The others had changed over the growth periods, as board composition tends to. At my retirement celebration, he said in his remarks that he had been on boards with a number of visionary founders, but that I was the most rigorous thinker he had worked with. He said rigor as though it were the highest compliment, which for him it was, and which I received as such. Min gave the technical remarks at the same event. She spoke for 7 minutes about the development of the MAST platform, its origins, its challenges, the specific problems that had taken the longest to solve, and what solving them had produced. She spoke in the precise, unembellished language of a scientist describing work she understood completely, and when she finished there was a specific quality of silence in the room that I recognized as the silence of people who have understood that they have been in the presence of something real. I thanked her afterward. She said, "You built it. I helped you prove it." I said, "You helped me build it and helped me prove it." She considered this. She said, "Fair." That was the whole conversation. It was accurate and it was enough. I think about the signing morning sometimes, specifically the 47 minutes between 8:17 when the patent confirmation arrived and 9 when I walked into the meeting with Wesley. I made coffee. I read through Clara's notes one more time. Not because I needed to refresh myself on them, but because reading them slowly was a way of giving the confirmation time to settle into the morning properly. I sat at the desk in my apartment where, in my first life, I had spent 4 years of evenings fighting for what I had built. In my second life, that desk was where I had spent 2.5 years building the documentation that made the fight unnecessary. There is a specific quality to having used time correctly, to having spent the available hours doing what needed doing rather than discovering afterward what should have been done. I sat at that desk with my coffee and the confirmation on the screen and the morning light coming through the window, and I felt it clearly, the quality of time used correctly. Then I picked up my jacket, put the confirmation in the inside pocket, and went to meet Wesley. He never got to steal what was already mine. Because this time, I had already made it mine, documented it, filed it, structured it, and protected it before he knew he was planning to take it. The right moment to protect what you have built is always exactly now, and I had learned that lesson in the specific way that lessons stick, from having failed to act on it once and lived to understand the cost. Min became Chief Scientific Officer in the quarter following Wesley's departure. The appointment reflected what her role had always actually been, which made the formal title both correct and, in a specific way, overdue. She looked at the letter and said, 3 years late. I said, 2.5. She said, I wasn't counting the 6 months it took you to convince me you'd changed your approach to documentation. I said those 6 months had been necessary, and she agreed they had, and we moved on. The series be closed as planned. 2 investors withdrew when Wesley left. He had built personal relationships with them that did not survive his departure. Clara had anticipated this, and the round was structured to close without them. The investors who remained were the ones whose due diligence had been based on the science rather than on Wesley's relationship with them, and they stayed because the science was exactly what it had always been. The launch happened on the 23rd of October. My name was on the patent. Min's name was on the research collaboration records. The board presentations I gave used precise technical language about what the platform could do, what it could not yet do, and what the development roadmap was built on. Investors who understood biotech found this more credible than the vision-forward language Wesley had used. They were the investors worth having. I kept the company for 9 years after Wesley's departure. The MAST platform was licensed to 3 pharmaceutical firms in the 4th year. The licensing revenue funded 2 subsequent research programs that Min led. The company went public in the 7th year at a valuation that reflected what it had actually built rather than what a pitch deck had promised. Wesley spent the years following his resignation moving between advisory positions and early-stage ventures. I heard about him the way you hear about people in the same industry from whom your path has genuinely diverged, occasionally in second-hand accounts, at sufficient distance that the information arrived as professional context rather than as anything requiring response. He had started 2 companies since Helix. One had closed in its 2nd year. One was still operating in a space adjacent to precision medicine. I did not track him closely. I had more interesting things to track. I think about Dr. Brennan occasionally, not about Wesley, whose logic I understand completely and whose complete comprehension removes most of his power to occupy space in my thinking. But Brennan, who had signed a clinical document about a person he had never examined, in the specific service of a man who had a financial stake in the document's conclusions, Brennan I returned to with a cold and particular curiosity about what the accounting looks like from inside it. In my second life, the Brennan report became one of the documents in the sealed envelope I gave the board chair at the start of the meeting. The brief described it accurately and specifically: the absence of a clinical relationship, the financial incentive of the commissioning party, the language that echoed Wesley's own framing of my behavior rather than any clinical assessment framework, and it was filed with the regulatory board the same morning. I have not followed what came of that filing. I had made the record. What the record produced was not my concern to manage. What I think about when I think about Brennan is the specific moment he chose to sign the document. The moment between understanding what was being asked and doing it. Whatever calculation happened in that moment, I think about the fact that my name was in that calculation and that he had made a choice about my professional life on the basis of someone else's account of it, without meeting me, without examining me, without the basic professional obligation of understanding what he was signing. I think about that, and then I put it away and go back to the work, because the work is what I built, and it is still there, and it has always been the thing most worth returning to. I filed the patent at 8 in the morning. He slid the agreement across the table at 9. I read every word before I picked up the pen, and I signed it with the confirmation number in my pocket and 3,700 pages of documentation behind it, and Min's collaboration records and Clara's IP clause and the knowledge, clear and complete, and arrived at the hard way, that the right moment to protect what you have built is always exactly now, before anyone else can decide when that moment is. He never got to steal what was already mine. Because this time, I had already made it mine before he knew